Hi, I'm attorney Greg Dell here with attorney Cesar Gavidia. And Cesar, this is an interesting case that just came out the other day out of the district court in Tennessee against Unum Insurance Company. Not the type of case that we would ever likely get into litigation with them over just because of our level of experience. I find that we read a lot of just unnecessary litigation or bad cases that are out there because of what I consider to be either overly aggressive attorneys or inexperienced attorneys who take on these cases, and kind of the people who like to just pick fights but aren't really understanding the big picture of what's going on. So this was a real unnecessary case, but I like the fact pattern that came up in this case that you're going to discuss dealing with the video and IMEs, because it's something that we deal with all the time. Unfortunately, there was no ruling in this case, but let's talk about the importance of timing and filing lawsuits, because people are frustrated when their claims are denied or they're having issues and they just want to sue. And again, this is an ERISA case. So give a little background and then we'll talk about some issues.
So this case involving Unum was brought, like you said, in the Eastern District of Tennessee just actually, last year. And this involved a claimant by the name of Lisa House. And she was a Toyota plant employee, and she'd been on disability since 2000. Wow. And in 2018, Unum wanted to submit her to an independent medical examination. They had questions regarding her, medical functionality or physical functionality, and they wanted her just to submit to an independent medical exam.
So that is something also, another thing we always talk about. So people, claimants think, oh, I've been on claim for 18 years. This is a perfect example of an 18-year-old claim, and Unum is reevaluating
18 years,
with an IME, right. So you are never safe.
Never.
I mean, unless you have some catastrophic injury, you're never.
Right.
But anyhow,
and I think that's perhaps maybe some part of what made it so frustrating for her. She attended the independent medical exam, or the IME, and we don't really even call them IMEs from our perspective because they're required and they're compulsory medical exams, really. And she attended it with a friend, and the friend was there to videotape and document the examination. It's something that we often request. But we request it with the understanding that the insurance company doesn't necessarily have to allow you, in an ERISA case, to attend the examination with someone or to videotape it unless there's really some medical necessity for it. If your doctor says they have to attend with a friend or something like that, then maybe there's the insurance company would comply, but there's nothing in the law necessarily that says they have to allow you to attend with a friend or to videotape the examination.
Well, counter to that is the policy doesn't say anything about whether you can or can't have someone. Now, my perspective has always been, you go to the doctor, your wife has something going on, and you want to go in the room, the doctor doesn't say you can't come in the room.
Right.
So why shouldn't, if you had to go to an IME, be able to bring someone else in there?
Right.
The other thing is video camera. It's ridiculous that a doctor doesn't allow or says no to a video camera, because you can set that video camera in the room, set the picture, a widescreen or whatever. No, another videographer doesn't need to be in there, and film what's going on and leave. There's no outside influence whatsoever.
In today's day and age, when you see everything caught on video, you would think the doctor would want that, just from the standpoint that, hey, that means that they can't twist anything I say. They can't say I did something inappropriately, that I didn't do the proper testing, because I'm going to do everything properly, and it's going to be captured on video. So you would think that the examiner would agree to that type of thing, or Unum would want that, that as well.
The video would be great.
But yeah, you're right in terms of the video being a way to keep the doctor honest, the process honest, and maintaining kind of integrity, if they want to call it that, with the whole examination.
All right, so this claimant shows up with a friend, with a video, and
the doctor doesn't allow it.
Did they even get there? Did they get
They get there, and the doctor says, no. Look, I don't have any prior authorization to have this done. I can't conduct it in this way. And so Miss House left with her friend, went back home, and then the dispute kind of continued with Unum after that. They probably, it's not clear in the case order whether Unum attempted to reschedule the examination, but it's been our experience that usually if they don't follow through with the first examination that's scheduled, Unum or the insurer will try to make an attempt to schedule another one and work with the claimant and have it done, under the requirements or guidelines that they're setting forth at that point.
Certain states do require the video to be allowed. It's different in every state, and we litigate it all over the country. But the problem in this case was that this lawyer who gave bad advice, or I don't know if the lawyer who litigated the case advised the claimant at that time. Well, obviously the lawyer knew about it because the lawyer's decision was, okay, you know, you're not going to allow the video, we're going to sue you now.
Right. So they're probably relying on something statutorily in Tennessee that might suggest that a claimant in an insurance case is allowed to have a videographer present or a third party present. That's found in many states, like you said. But in this case, you know, it's governed by ERISA. So there's not really state laws here that are governing because ERISA completely preempts state law.
Right, but who cares? Why was the lawsuit filed when benefits were still being paid?
Right. So they get to federal court because once they impassed on that question of whether, you know, she could have the friend there or the videographer there, they just immediately filed suit. And the first thing Unum did was to file a motion for summary judgment to seek dismissal of the case on the grounds that, one, she didn't attend the independent medical examination, and two, that the claimant failed to exhaust administrative remedies. Now, what that means, and you know, when you get denied by Unum or when there's some sort of adverse decision, in their denial letter, they should state that you have a certain period of time, usually it's 180 days, to appeal that decision administratively with Unum before you can even go to court. And the federal law and the case law supports that this is a process you have to go through before you could bring a federal court lawsuit in an ERISA case. The Unum kind of won this hands down. There wasn't really any question to the federal judges that the claimant, before filing suit, would have been required to undergo or go through an appeals process to have Unum have this issue of whether she should attend the independent medical exam with a third party or with with the videographer reviewed by an independent panel.
So
there.
this to me, if you and I got this case, a no-brainer in 2 seconds, we'd say, don't even waste your time.
Right.
So this lawyer files the lawsuit and tries to say, we're going to argue the futile exception, that it would be futile to go through the appeal process because we know no matter what we do, it's going to be denied.
Mm-hmm.
Well, that applies in a situation where you've already been denied.
Mm-hmm.
And maybe you already sent something in, or you already saw a letter from someone that said, it doesn't matter what you send us, we're going to deny you. Or a letter from the carrier saying, we're not going to consider another MRI. Okay,
Right.
well then why do I have to send you in anything? There's many, many situations where it can be considered futile. But in this situation where you're already getting paid, now, the only one thing I could think the doctor was saying was, well, it's imminent that they're going to cut her off. That the lawyer was thinking. It's imminent that they're going to cut her off, so I'm going to go ahead and sue him right away so I don't have this downtime of my client not getting any money. That's the only thing I can think of. But it's still a loser.
Yeah.
You know, and that's what I tell clients all the time is that, look, we could file a lawsuit in a certain situation, but it's just going to get kicked back. It's not going to do anything. And then we're going to delay the process even further because now we're assuming this claimant continued to get paid and is still possibly getting paid.
Right.
So what the hell? What were you fighting over? It doesn't make any sense.
It really doesn't, and what it does is it kind of frustrates the whole process and the whole system because, especially for this claimant, you know, now she has to kind of go all the way back to where she started and go through the process again.
Well, what's interesting here, and when you told me about the case, I was kind of, excited waiting to hear. So can you bring a videographer and a person to attend, or can you not? And this court, as far as I'm concerned, still didn't answer the question.
I don't think they came out directly and stated that you're allowed or not allowed to have a videographer. What they said was it's not a question of statutory interpretation. It's a question of contractual interpretation, and the plan documents didn't specifically express that the claimant's allowed to have a videographer or third-party present during the independent medical examination. So they took the path of like kind of a strict interpretation of the policy language, and instead of, if the policy language does not state it, then you aren't really entitled to it. I think that's what they were trying to say in an indirect way, but then they went back around to say you can't argue futility based on the IME question.
Unfortunately, if it had a discretionary clause, it's going to say that the carrier has the right to interpret the terms of the plan, and they do. But it still has to be reasonable. So the ultimate question is, which the judge has never reached, which I would love for a court to rule on this ultimate issue is it reasonable for a doctor supposed to be examining a claimant to refuse video in this day and age in the room.
And you know what's interesting is that we've handled thousands of Unum cases at this point, and we in every case of an independent medical exam, I always request a videographer or a third party be present. And the importance of that is that even if the third party is not videotaping it, I have them take notes.
Right.
I have them observe, as an independent third party observer, what's going on, the questions being asked, the examination that's being done. Take real thorough notes of the process. And most of the time, Unum doesn't object to it.
Right.
Usually they say that's fine.
Right.
So it's kind of really unusual here what's happened here. The only thing I could think of is maybe the doctor, like we were talking about earlier, didn't want to be under scrutiny of video.
So you tell Unum, like we tell them, in Tennessee, what kind of doctor was this? An orthopedic? I don't know what it was. There's got to be 500 plus of that particular doctor. So when you say to the company, suggest find another doctor that will allow a video. Find another doctor within 50 miles away. Our client will go there. Now you shift the burden to Unum to show they're acting unreasonable. That's what a skilled lawyer would do representing the claimant. You shifted to all these situations to say they were being unreasonable. Ultimately, at the end of the day, your claimant has to go show up there. Now, and I've litigated this in other cases. Again, didn't get a court ruling on the particular issue, but claimant's there, ready to go. Here's my video. Doctor says, I'm not seeing you. Who refused the IME at that point? To me, it's a no-brainer, the doctor.
Right.
I'm here, doctor, with my videographer. You don't want to see me? You refused. Not me. I'm ready to go. And so I think that,
Well, I think that the claimant perhaps got very lucky here.
Yeah.
Because what the court could have done, and if it was another court, they may have done this. They may have looked at this situation and said, you didn't attend that independent medical exam.
Right.
You left, and therefore you failed to complete the conditions precedent to entitle you to further benefits. And they could have dismissed the case with prejudice. I think there was a little wrinkle in the fact that she was continuing to be paid, I think, through this period. So I don't think they could have necessarily done that. But if she hadn't been paid, I think that may have been the ruling here, that they could have said, your failure to attend this independent medical exam means that you failed to complete the conditions precedent.
Again, it depends on the facts. It depends if the doctor refused to see her or not, and we don't know. So, interesting issue, a really technical one, but something we deal with all the time in all of our IMEs, and the fact that I think it's important to think outside the box and think about, trying to avoid this unnecessary litigation, unnecessary delay that we know about because we've handled so many claims. We usually don't have these particular issues.
Yep.
So if you have a claim with Unum or any disability insurance carrier, feel free to call Cesar or any of our long-term disability insurance attorneys. We're willing to help you anywhere in the United States, and we always offer a free initial phone consultation. We look forward to the opportunity to help you.